behalf of the entire Asian American group, we appreciate you guys taking time out of your busy schedule to come down and meet with us this afternoon. I was told by some people that this was somewhat of a quiet weekend with respect to your respective campaigns. So we're glad we could shake it up and give you something to do, as opposed to hang out with your family and friends and relaxing, because there's no need for that sort of thing in a campaign of this nature.
That's really funny.
Just so you know, there are a couple people who could not be present today. Mr. Ashby, the fourth individual in this race, did not confirm. So we will be having a makeup day sometime next week, probably on a weeknight. We plan on getting our endorsements out for the judicial primaries probably the next 2 to 3 weeks. So we realize this will not be this is not the sexiest of race, let's be honest. Judicial races are pretty far down on the ticket, and it's an off election year, but it is still some many important decisions that need to be made. So first thing we would like to do is this, and we'll start with Jim, because I generally start on my right and go across. Perhaps you could give us maybe a minute to a minute and a half background on who you are.
Sure.
And why you've decided to run for this particular race at this point in time.
Okay, thank you. Thanks for the chance to meet with you. My family moved here when I was 3 years old. That was in 1952. I'm 65. And I went through all public school here in Las Vegas. And then I went away to college in Los Angeles, and I went to law school in Sacramento, the George School of Law. I graduated in 1974 as president of my student bar association. Took the bar and passed it, and in 1974 I opened my own law office with a $2,500 loan from Pioneer Citizens Bank. By 1979 I was starting to do some trial work, which is what I wanted to do, but it took that long to get cases that could go to trial. And by 1979 I formed a partnership that became Crockett and Myers, and that partnership still exists to this day, although my partner Richard has retired. In 1983, I had done enough courtroom trial work to become eligible to be board certified. So I applied for board certification, which means I had to offer the National Board of Trial Advocacy the names of the judges that I had tried cases in front of. You had to have 25 cases to verdict at that point. Also had to give them the names and addresses of the lawyers I've tried the cases against. I had to get the recommendations of both. Then I had to submit written briefs and motions that I had prepared as examples of my writing skills. And then I had to take a day-long examination, like a bar exam. I passed all that, and in 1983 I became board certified as a civil trial lawyer. And every 5 years since then I've had to be recertified, showing that I continue to do trial work and continue to get the recommendations of the judges that I've tried cases in front of and the attorneys I've tried cases against. When I was about 35 or 40, I knew from my experience trying cases that I wanted to be a trial court judge, but I still wanted to continue to be an advocate for a while, because once you are a judge, you are no longer an advocate. And so 25 years later, I think the time is right, and it's a 6-year term of office, so the decisions you're going to be making, not just for this race, but for all judicial races, are going to be lasting the citizens of this community for the next 6 years. So it is, in fact, very important.
Thank you, Jim. Tony, background and why this race at this point in time?
My name's Tony Liker. I've been in this town as an attorney for 21 years. I'm originally from Kansas, from a small town in Kansas. I went to Coffeyville Junior College, where we played football as well, so we were national champions there. I played for Dick Foster. You guys have probably never heard from him, but he was one of the winningest coaches in junior college football ever. And then I got John Elway's dad, Jack Elway, offered me. John Elway plays for the Broncos, or used to. He offered me a scholarship to Stanford University, so I went to Stanford University, which is, that and Harvard are probably the two best schools in the country. So I was, blessed enough to go there. I was first team All-American, All-Academic team. I was an honorable mention All-American, and I was first team All-Pac-10. I was drafted by the Packers in the 7th round, and I was a free agent with the Vikings. And I played for some famous coaches there, but I'll just go on. One of them was the head coach for the Seattle Seahawks now. He was the D-back coach in Minnesota. But anyway, I digress because it's really probably not that important to being an attorney. And then I went to law school at the University of Oregon. I had a friend, actually James Levin. I don't know if you guys know him, but he's on the Board of Regents. And me and him we clerked for the federal prosecutor's office. So we were federal prosecutors basically. We would do all the little trials like the DUI trials and go to do the park trials, because in Oregon they have a lot of parks that the senior federal prosecutors didn't want to do, and we would write briefs for him. So he told me, hey, go to Vegas because it's booming, you can get a job there. So he was the first person that told me to come to Vegas. So I clerked at Beckley Singleton, which at the time was, I think, the second largest firm, 55 attorneys. Did that for a summer. It was mainly insurance defense, and I decided that I wanted to be a trial lawyer. I wanted to be a prosecutor, so I took a job in Nye County as a deputy DA. I did that for about a year, and then I had some jury trials there, and then I became a city prosecutor here in Las Vegas. So I was a prosecutor for about 5 years, and then I've been in private practice for about 15 years now, doing mainly criminal defense and family law and personal injury. I've done over 300 trials. Most of them are bench trials. I got a really good reputation here in town. I always try to come to the Asian events. I want to impress you guys with my linguistic skills here, because I know the Asian languages. Chinese, I know ni hao and shay shay. And in Tagalog, I know salamat po, adobo, the most important words, adobo, pancit, lumpia, and Manny Pacquiao, of course. And so, I do know a few words. And I had a fiance for a while. She was a really good girl. And I didn't tell her I was going to meet her, but we could call her right now. And she's a real good friend. She's a Filipino, Mara. And I know in the Asian community that loyalty is very important. When you have an Asian friend, you're going to have a friend for life, and they'll fight to the death for you. And so I've always been really impressed with the Asian community here in general. And I have quite a few Filipino and Chinese friends and other Asian friends. And I can't tell you how I rule, but I kind of got a heart for the Asian people. And I've watched Manny Pacquiao fight a lot of times. So.
Joe.
Thank you. First, want to explain that I am not wearing a suit. I came from my other younger son's baseball game outside, so kind of a little casual this morning.
Well, Joe, just to cut you off, I'm not on camera right now, but none of us are wearing suits either.
Exactly.
So we won't take that as any offense.
Thank you very much. So my name's Joe Hardy Jr. I grew up in Boulder City, third generation Nevadan. My father's Joe Hardy. He's a state senator. That's why in this race I'm going by Joe Hardy Jr. So I always have that junior on there now. I went to undergrad at BYU and law school as well. While in law school, after my first year of law school, was looking for a job for the summer, and typically firms don't hire first year law students because they don't know a lot. And they don't want to pay somebody, who doesn't know anything. So that, I was calling firms and they all confirmed that. So then the next option was to see if I could extern for a judge. And so this was pre-Google days, but they had Westlaw was around, so you could do a search in this special program that used the internet. So I did a search on judges here with BYU connections, and the first judge that popped up, luckily for me, was Judge Lloyd D. George. You may have heard of him if you've seen that big building there on the boulevard. It's named after him. This was before the building was built, but so anyway, his name was on there, and I'm like, okay, I'm going to call him up and see if I can extern for him for the summer. So I called and spoke to his assistant, and his assistant, bless her heart, said, well, do you want to speak to Judge George? Like, I had no expectation of talking to him, you know, on that initial call, but she got him right on the line, and we were talking, and turned out we knew some people in common, and he offered me a job on the spot. Fantastic experience externing for him that summer. We got to sit in trials, we got to listen to all sorts of hearings. Couldn't ask for a better experience. So that's where I first got the idea that, one, I wanted to be a litigator, I wanted to work in court, and two, eventually, you know, maybe I would want to be a judge like Judge George. He's a guy who, you know, could have been a, you know, extremely wealthy trial attorney, but instead decided to serve the public by becoming a judge and staying with that. You know, he's obviously still a judge. So I started, after that, the next summer I worked actually for the firm Tony worked for back in Singleton, great litigation firm. Worked there for my first 5 years or so out of law school, doing mostly commercial litigation, so business-related lawsuits. Did some pharmaceutical cases, represented both businesses and individuals in all types of litigation. Went from there to a regional firm where I eventually became at that firm a partner. Again, doing that same type of, all types of civil work. And then I went to the firm where I'm at now, which is Gordon & Reese, national law firm, one of the top 100 largest firms in the country. We have a smaller office here, and the co-managing partner of the Las Vegas office here, where we do all types of civil litigation, pharmaceutical litigation, representing individuals, homeowners associations, other attorneys that have been sued. I also am very actively involved in the community. I've worked a lot with the Boy Scouts of America. I was a Webelos leader, and then I take assistant scoutmaster, then a Webelos leader, and most recently a Cub Master. So working with the Boy Scouts and Cub Scouts. I serve on the Nevada Taxi Cab Authority Board, was appointed 3.5, 4 years ago, and then was recently reappointed last October by Governor Sandoval to serve in that position. That's given me a lot of experience in terms of deciding tough issues, you know, because we have people from both sides come before us, both in terms of drivers who have been fined and are appealing, and also in terms of allocating medallions. I'm also, I've been for 8 or so years an arbitrator for the Better Business Bureau. Again, great experience there for what a judge does. You know, you hear both sides, and you know, you have to make tough decisions based on the facts and the law before you. I was recently appointed to serve on the City of Henderson Charter Committee as well. So why I'm running, I believe in public service. I believe that we need good people in government, and government includes the judiciary. Most folks, you know, the judiciary, like I think you said, John, maybe it's kind of the forgotten branch, if you will, but it's a very important branch as well, and so that's why I'm filing or running for this seat.
Next question I guess the first question technically, start with Tony and then rotate around again. You know, the judiciary, the public has some negative perceptions of the judiciary, and one of the more recently high-profile reasons behind that is how we as attorneys donate money to campaigns to elect judges, and then they begin presiding over our cases. How do you, assuming you are elected, how do you plan on trying to minimize the appearance of impropriety when it comes to individuals or corporations, entities appearing before you who may have given you money, how do you plan on trying to minimize any impact that that may have upon your rulings and the administration of justice?
Well, when I first started talking, I didn't say that, the reason why I want to be a judge is because I like helping people. And you got to be fair. You're going to help people. You got to give both sides a fair hearing. And last thing you want is to have a judge that's going to have the case decided already because they're buddies with somebody, and that's not right. That's the total antithesis of being a judge. You're supposed to be fair. I know there's one case. I won't say the judge's name, but he actually took $5,000 from a litigant. It was 3 months after the case was over. He took a $5,000 donation, and the Supreme Court for some reason said that was okay. He took a $5,000 donation from somebody that was it was a guy that was in a case before him, and to me that's just awful. I mean, I've never I've talked to some of the judges about it, and they said they would never do that. I definitely would never do that. But you got to be fair, of course. I mean, that's the main thing that a judge has to be. And I would like to say that Mr. Hardy, I think he didn't say this, but he was cum laude at BYU, which that means he's top 5%. That's very impressive.
Not quite 5%.
But I want you to vote for me. But he does.
I would, for election purposes, I'm sure you're not vouching for another candidate in making that statement, merely pointing out something, a fact on his placard.
Right.
Just want to bill you out there, Tony.
Okay, thanks.
Just looking out for you. Joe, appearance of impropriety with people donating to you or family members, I guess, in your case.
Yeah, well, the family members, I think is pretty easy. I would recuse myself.
I'm sorry, I mean people donating to your father, perhaps, and not having a disproportionate impact upon your rulings, assuming they are a friend of your dad's.
Oh, okay.
Who's obviously been a public eye.
I was gonna say, yeah, I'm not gonna decide a case of my dad's. Okay, gotcha. Disclosure. We need full disclosure. That's fairly easy to do. I'll never forget having a case when I was a young attorney. Judge Betsy Gonzalez, she had been a partner at Beckley Singleton, only briefly when I had worked there for the summer, but she had been a partner of the partner I worked for, and we had a case in front of her, and she, made it clear to both sides, how many ever years ago. This was 2 or 3 years after, probably even more than that, after she had left Beckley Singleton, but she still disclosed, look, however long it had been, she had been a partner at Beckley Singleton, and asked if anybody had any issue, and she stated, and I think this is fair, that she believed and felt that she could be fair and impartial to both sides. I mean, Las Vegas is a pretty, especially the legal community, right, is still fairly small. So you're going to have those cases where people come before you and you have some type of connection. So full disclosure, I believe in being, like Mr. Liker said, fair and impartial to all sides and all parties. And in my practice, I have represented both plaintiffs, the people who are suing, and defendants of people who are being sued. So full disclosure, and if it's, for example, like my current partner, he, luckily for me, contributed to my campaign. That'll be on, when we do our disclosures. With him, I would have to recuse myself, because I would believe I could be fair and impartial, but I could, it's a reasonableness, and I could definitely understand the public, having that concern. So I would recuse myself in his case.
My partner was business associate, was recently elected to the justice bench, and I don't want to appear in front of her anyway. But I'd be like, hey, what's up? I mean, Your Honor. That would be awkward. So I completely agree with that aspect as well. Jim.
I agree that disclosure is the only way to deal with this. There must be complete transparency. It must always be clear and apparent who gave how much to a campaign. And I disagree with one thing, though, that Joe said about thinking I could be fair. I would like to think that I could be fair and impartial, but there are circumstances where I think I might try so hard to overcorrect and overcompensate, I might go the other direction and decide against somebody who deserves the decision to avoid the appearance that I've been influenced or improper. And I think it's just a trap that we fall into as humans, you know? We're thinking, well, I'm sure that everybody thinks that I'm going to be totally biased in favor of John Paris because I've known him for 25 years and yada, yada, yada. I'm just going to show everybody how fair I can be by being unfair to John. And so that would be the fear that I would have. So I do agree with Joe that I think that when in doubt, recusal is the best possible way to deal with it. Because I remember I heard the wisdom of Judge Howard Babcock, who probably died long before anybody here would have remembered his name, but he was just one of the sweetest, kindest, most compassionate jurists. And somebody was talking about impropriety, the appearance of impropriety. And what he was explaining to somebody was that it is vitally important to the litigants that they feel like they've been given a fair shake. He said, I could be Solomon, but if one of the people who's appearing in front of me doesn't feel, if they have doubts, if their perception is, I think things are twisted, I think things are leaning here against me, he said it's vitally important that the judge remove himself from the case so that this party can, when everything is said and done, when a decision is made, the person can think, okay, well, I had my day in court and I don't have any questions about the judge's fairness. And I'll just quickly tell you that one of the horror stories was my partner, we, for 40 years, we're used to being hit on for campaign contributions. It's just, all the time. And one day I was in my office and the receptionist buzzed me and she said, Justice so-and-so is here to see you. And I said, oh, and I'm panicked. I'm looking at my calendar. I didn't know what was going on. And but I jumped up out of my chair and went out, greeted the justice, and this is a long time ago. The person's dead. And I said, hi, I'm sorry, I didn't know. Were we supposed to? He said, no, I just, he says, wanted to just talk to you and stuff about my campaign. I said, oh, okay. So I quickly went and got my partner, Rich, brought him in. And the justice is talking to us and everything about, how expensive these campaigns are. Oh, yes, sir. Yes, we know they are. They're very. And he says, I got some stiff opposition this time, and I know I've always been able to count on you and Rich in the past. Yes, sir, absolutely. And he says, and whatever you can give. And he says, and I want you to know, I noticed that you have a case in front of us next Friday at 1:30 for oral argument. I don't want you to worry about that at all, because whatever you can do or not do will have no bearing on the case. My partner, Rich, was sitting slightly behind the justice, and Rich looked at me like, whoa. Yeah. So, of course, we gave to the justice's campaign, but when the justice left, Rich turned to me and he goes, wow, I feel like we were held up. And I said, yeah, that's pretty weird. That's pretty weird. So, I haven't seen or heard other stories like that for about a decade, which to me is a very good sign, because I used to hear those kinds of stories all the time. But I think if it's transparent, if it's all disclosed, if it's a matter of record, Judge Denton, sometimes when somebody would appear in front of him, he would say, Crockett and Myers, I just want you to know, they gave $5,000 to my campaign. He'd say to the other side, he'd say, so, if you have a concern about that, speak now or forever hold your peace. And I don't think anybody ever quarreled about it, but that's the way we did it.
Kind of dovetails with our next question. You're referring to basically shakedowns.
Yes.
There are certain things that we have a lot of experience sitting here in front of us. What are some things that you've seen judges do, some of the more egregious things that, I don't know, other than that which you just mentioned,
Right.
that you yourself have vowed never to do. And maybe we can focus more on that while they're on the bench in their judicial capacity rather than in their political fundraising
Right.
capacity. What's something you've seen that you vowed, if elected, I cannot do anything like this, or I need to avoid doing things like this?
I have fewer concerns about corruption and dishonesty over the last 10 years than I ever had before. So instead, my concerns actually have to do with the professionalism and the work ethic of the attorneys who appear in front of me. Because one of the things that we do, as you know, John, is when we're waiting for our case to be called, we're sitting there and watching the other things take place in front of us. And there are some judges who let attorneys go on and on and on when they've said what they have to say. And instead of the judge saying, okay, I got what you got to say, let me hear what the other side has to say. And so he's just burning up the time of everybody else in that courtroom, times the number of lawyers who are there. The other thing that I think needs to be rectified is, I believe that litigants need to know that discovery is a hostile place for non-disclosure. Because I truly believe that when lawyers find out the strengths and the weaknesses of their case, they are much better equipped to evaluate it for settlement, to get it out. Because although there's been a great deal of talk about an intermediate court of appeals and everybody's on board to do it, my philosophy after 40 years of litigation is the way you reduce the court backlog is to get the cases out of the system. And the only way you get cases out of the system is to resolve them. There is no case that leaves the system unless it is resolved. Appealing it doesn't resolve it, it extends it. Appealing it twice doesn't resolve it, it lengthens the time it's in litigation. And when people conceal information at discovery and try to wait and drop it on you at the last minute, that didn't get play in the litigation. So the other side didn't know about it, they weren't able to evaluate, you didn't know about it, you weren't. And I have found it in cases where cases are won and lost in discovery. And the sooner that the judges appreciate that and set a hard line on discovery, which will trickle down to the discovery commissioners, I believe you will see the case backlog just start to dissolve at a very reasonable rate. Cases will be coming in about the same time, the same rate that they're going out. So that's where I think the focus should be.
Tony?
Yeah, some of the egregious things that I think are, when you have judges that don't have experience and they're on the bench, so they don't really know what they're doing, so it takes them years to get caught up, and then they really don't even still get it. So if you're an attorney, I'm 49, I'm 49, so I've been practicing law for 21 years. I have a lot of experience, and with all due respect for everybody here, there's 4 of us in the race, and I'm the only one that's a former prosecutor that I know of. So we're all going for Judge Bixler's spot, who's retiring, and it's
I'm sorry to cut you off, Tony. There is no incumbent on this race either. We had this come up in front of for the previous case with Judge Vega. It's very rare that we don't have incumbents. So I'm sorry to cut you off there. I'm trying to make that clear to everybody. There's for the notes that we have, it is notated if there is an incumbent.
Right. So
Tony, please.
So it's going to be half criminal and half civil. And so, I have a lot of experience in both areas, but like I said, I'm the only one I'm a defense attorney, and I was a prosecutor for 5 years. So I don't think you want to get somebody on the bench that doesn't, know what they're doing as far as having been a prosecutor. And I'll give you this example. If your daughter was accused of rape or murder, wouldn't you want somebody that was on the bench that was a former prosecutor and also a defense attorney? If they were accused of, if they were the victim of a rape or murder, I'm sure it would be the same story. You'd want somebody that was, former prosecutor on the bench. Like I said, I mentioned that thing. I think that's really egregious. Although I guess the Supreme Court rubber stamped it, taking $5,000 from somebody that appeared in front of you. I don't care if it's 10 years later. That's really egregious. I've never heard of anybody ever doing that in any part of the country, and I definitely wouldn't be doing that. I would be fair and impartial. My thing is I think a lot of the judges, you know, I'm 49. I'm ready to be. I wanted to be a judge. I've ran a lot. I've come to Asian events. I've been trying to be part of the community for years now, and I want to be a judge because I like helping people. And to me, that's the you get to help people. Being an attorney, when I worked for Beckley Singleton, I didn't like representing the insurance companies or the banks. I wanted to help people out, and they have rights too. But I wanted to help people. I want to interact with people. So a judge is in the best position, even more so than an attorney, to help people out and help them get through the process and make sure that they feel like they're getting a fair hearing. So I'm like the opposite. I think a lot of the judges, that, especially when they get older or they've been on the bench longer, when you get entrenched, it's harder to get rid of judges off the bench. I mean, it's very hard to get rid of an incumbent if they're a bad judge. And they don't want to listen to the parties, and they don't want to do the trials. I mean, there's this hearing. Well, we need to start pushing these cases, and so that we don't have to hear all the trials. We can't do all the trials. Well, to me, it comes down to laziness. My dad was a tried rubber worker for 35 years, and he always told me, Tony, you got to work hard. One year, I remember he worked every Sunday, every Saturday except for 4 Saturdays, and he always told me the worst habit you can have is to be lazy. And I think, we got a lot of great judges, and I'm not singling anybody out, but if your whole goal is to retire or to get off the bench by noon so you can go home to lunch and go golf or something, you shouldn't be on the bench. And so you need to listen to the parties. If they're repeating themselves, I agree with Mr. Crockett. You got to say, hey, listen, you went over that. We got to move on. But you don't want to be cutting people off and think you know everything, because what ends up happening is the attorneys that get the that are juiced in, so to speak, or working for the big firms, they're the ones that end up winning more. You want to have a judge that's willing to listen and let it go to trial. The law says that every issue is supposed to be determined on the facts. It shouldn't be a popularity contest over there in the courthouse. You should listen to what everybody's saying, and if if it doesn't settle, don't be lazy. They get a trial. They get a trial on the case. If you think that that was without merit, then the law says they should get a trial. But then you can sanction, you can give attorney fees on issues. But what we don't want to have is, unless you're like a billionaire or something, or a multimillionaire, if we're going to do it, we're going to say, hey, we're going to cut people off. We're going to try to stop their right to go to trial. Guess who's going to lose? Is the billionaire going to lose, or a millionaire, or the rich people? They're not going to lose. It's going to be your average Joe and Jane. And so the bottom line is I'm definitely not for that. I think that's a problem, and we got to be willing to work. We're on the bench to work, not to leave at noon or take a vacation.
Joe, what do you vow not to do, assuming you are elected?
Sure, thank you. I was going to ask if I got the question right. The example that came to my mind, luckily, before I go into that, like Mr. Crockett said, I think our bench has vastly improved even from the time when I began practicing. And that's probably one of the reasons all of us are running for an open seat. But the most egregious example that I could think of in a case where I was the attorney, we were appearing in front of a judge, and I was a pretty young attorney. Judge didn't know me from Adam, so to speak, and sitting waiting for our case to be called. The judge had a sign up there that said, if your paper's not timely filed, I'm not going to consider it. And the judge was hearing a motion in another case and made that point in that particular case, said, look, your paper was late, I'm not going to consider it. And so I was sitting there thinking, oh, well, this is good for me, because in my case that we're here on right now in front of this judge, their paper was late. Not by a day or two, that I could understand, but like a week or so. So I'm sitting there thinking, oh, good, this is, I did raise this in my brief, and I'll start off with that and be prepared to argue the substance just in case. And so I stand up and start going into that, pointing out how their brief was late, and this particular judge said, "Mr. Hardy, I don't care, you know, move on to the merits." And it was, I mean, you know, I was a young attorney, like I said, and attorney on the other side had a name, you know, if you will, and it was a shock to me, and so that's something I would vow never to do. I want to, and I will, you know, if elected, treat everyone meaning all parties on both sides, and also all attorneys, you know, fairly and impartially, regardless of whether I've heard of them or not.
We're right up against our time limit, so I'm going to give each you guys 30 seconds, and I'll unfortunately have to hold you to 30 seconds.
Hi.
Sorry. I'll have to hold you to 30 seconds. We'll start with Joe and finish with Jim. Last 30-second pitch.
Thank you for having me, first of all. I wanted to point out that I do have 3 members of the Asian American community on my committee, 3 attorneys, Tina Yan, Lauren Payne, and Jude Nazareth. I welcome your time. I know it's valuable as well. Like I said, I have represented both plaintiffs and defendants on both sides. I've represented parties in all types of civil litigation, and I will be fair and impartial, and you don't get to where I am being a co-managing partner at a top 100 largest firm by being lazy. I will continue to work hard and diligently on the bench.
Thank you. Tony?
Yeah, I'm sure that I want you all know that I'm very much try to be involved in the Asian community, going to their events. I've got a lot of friends that are, Filipino or Asian, and I'm sure that I've astonished you with my linguistic, skills with my Tagalog and yeah, and no, I'm joking. But I do have a lot of heartfelt feelings toward the Asian community and the friends that I have. And, I've been an attorney 21 years. I'm 49. I got another 20, 30 years left in me. I work really hard and be fair. And I think everybody has a right to go to trial. As I said before, I'm the only former prosecutor in the race. I think that's a big difference, especially when half the cases we're going to hear are criminal.
Jim?
When I was a young attorney, I had a horrific experience with a judge who, I didn't realize it, but he was basically bought and paid for by the defense, but I was too unsophisticated to realize that. So I had a big medical malpractice case, wrongful death of a 13-year-old girl in front of this judge. And the judge tanked me at every stage of the proceedings, kept out my expert witness, kept out their own policies and procedures against him. So when I got a defense verdict against my client, I appealed, went to the Nevada Supreme Court, and they overturned him and sent him back down and said, try it this way. So the judge was given specific instructions as to what he was supposed to do. And in defiance of the Supreme Court, again, to guarantee his buddy's decision in their favor, he tanked everything even the Supreme Court said. So I went back up a second time to the Nevada Supreme Court, and I reversed him again, and for the first and only time that I'm aware of, I persuaded the Supreme Court that consciously or unconsciously, this judge has a prejudice against me or my clients and is trying to sabotage our case. And I ask you to remove him from the case and randomly assign it to anybody else. And they did. And so the third time I tried this case, we won. But it took me 13 years to get justice for my client. And in the time that the case went on, my client's father died. So he never even saw the justice for his daughter. The mom still lived and saw justice, but Dad died after the second trial and never saw the justice that the jury gave on the third trial. So I'm very passionate about a judge being fair and unbiased to both sides.
Perfect. Well, again, we really appreciate you guys coming out today.
Thank you very much.